Guys didn't leave me a lot of room up here with these microphones. You know, I'm supposed to get a whole podium. Well, good afternoon, everyone. I just wish to briefly thank everyone for coming. For those of you who do not know, my name is Greg McCaffrey. I am the Livingston County District Attorney. We are here today to give some details and give a brief statement surrounding the investigation into the employees of the Livingston County Jail. This press conference is related solely to the criminal investigation, and county officials are not going to be present here today. We will not be addressing any issues that are related to the administrative county business at this specific press conference. When I am finished, I would be happy to address any questions that members of the media may have, and believe others who are also here to my right will also be available to answer any pertinent questions. To best facilitate that at the end of this press conference, I would simply ask each member of the media to briefly identify yourself as well as your news agency prior to asking a question. Just for brief introductions, present here as well, to my left is First Assistant District Attorney Victor Rowcliffe. To my immediate right is Captain Rick Allen of the New York State Police. To his immediate right is Senior Investigator Rick Kemp from the New York State Police. And, oh, I'm sorry, I didn't even look.
It's okay.
In the middle, that's our Sheriff, Thomas Dougherty. And to his right is Senior Investigator Rick Kemp. Just to give this matter a little context, I think it is necessary to go back to the very beginning when this matter was first brought to everyone's attention. On November 28, 2012, County Administrator Ian Coyle received an anonymous letter detailing corrupt time card practices by employees assigned to the Livingston County Jail, or according to the letter, under the table payouts. After a brief internal investigation by members of the Livingston County Sheriff's Department and county government in the beginning of 2012, which included interviews of a majority of the jail staff by the investigators of the Livingston County Sheriff's Department, including former Undersheriff James Cesniak, the District Attorney's Office was finally advised of the matter, at which point I made an immediate written request to the New York State Police for their assistance with this investigation. I was joined in this request by retired Livingston County Sheriff John M. York, who understood and agreed with the necessity of having an outside law enforcement agency overtaking the review of the potential misconduct of members of our jail division. This request was also fully supported by county officials, including County Administrator Ian Coyle, as well as members of the Board of Supervisors. The formal investigation by the New York State Police began in January of 2013, and at that time, while aware of the general nature of the allegations, I do not believe anyone anticipated the scope, magnitude, and amount of documentation and investigative work that would be required to thoroughly complete this investigation. I am here today to tell you that because of the thorough and diligent work by the New York State Police and the patience and cooperation of our county officials, as well as Sheriff Thomas Dougherty, that the criminal portion of this investigation is essentially complete and has resulted in the arrest of 9 former members of the Livingston County Sheriff's Jail Division. The 9 former members of the Correction Division were all charged with offering a false instrument for filing in the 2nd degree, which is a Class A misdemeanor punishable by up to 1 year in jail and a term of probation that could be up to 3 years, as well as a variety of other sentences, including fines, surcharges, community service, and potentially restitution. 8 of these men appeared in Geneseo Village Court at 9 a.m. this morning to be arraigned or formally charged on these accusatory instruments, and then entered guilty pleas as part of a negotiated resolution that has been in the works for several weeks between my office and their various attorneys. The following defendants pled guilty to criminal solicitation in the 5th degree and were sentenced to a 1-year conditional discharge, as well as the mandatory New York State surcharge by the Honorable Thomas Bushnell today in Geneseo Village Court. Jose Augusto Jr., Kyle Fisher, Timothy Frazier, Jeremiah Pratt, Thomas Schladorn Jr., Michael Simpson, and Marvin Umonico Jr. Mr. Augusto, Mr. Frazier, Mr. Pratt, Mr. Schladorn, and Mr. Umonico all resigned their positions at the jail last Friday, while Mr. Fisher and Mr. Simpson had previously resigned their positions at the jail. Andrew Eichhorn pled guilty today to offering a false instrument for filing in the 2nd degree as a Class A misdemeanor, and a pre-sentence probation report was ordered, which is returnable on July 8, 2014. I can state on the record that we will not be seeking jail time for Mr. Eichhorn, but wished to address any outstanding restitution relative to his case. It was apparent from the investigation that Mr. Eichhorn's conduct could be distinguished from the other members of the jail and was far more severe than the other 8 men, both in sheer number of times he lied, but also because of persistent overtime inconsistencies. Mr. Eichhorn resigned his position at the Sheriff's Office on May 31st, 2014. William Baker was the 9th man charged, and he was unable to appear in court this morning, and his matter has been adjourned until July 8th, 2014, at which time a plea offer to criminal solicitation in the 5th degree will be conveyed to him and in all likelihood accepted. I stand here today, ladies and gentlemen, with mixed emotions. There's an obvious sense of relief on behalf of myself and my entire office that this 17-plus month investigation is now complete, but I am left with a sense of sadness that there was a criminal investigation surrounding members of our county workforce, and more specifically, our county sheriff's department. I am honored every day to work side by side with members of law enforcement community and respect the work and sacrifice they do to protect our community. But again, I'm saddened that the selfish and deceitful actions of a few jail employees and the absolute lack of supervision and malfeasance by the prior sheriff's administration has led to the significant and prolonged investigation, culminating with the arrest and prosecution of 9 people. Further, and even more troublesome, is that there is little remedy and no applicable criminal charges against those who actually supervised the environment where this all transpired, including the former administration of the Sheriff's Department. I am fully cognizant of the rampant speculation that this entire investigation had disappeared a long time ago, and that there was never going to be any action against these employees. I am keenly aware of criticism that the investigation was purposely stalled due to last year's contested sheriff's election or some other form of political cover-up, but I assert to you that nothing could be further from the truth. This investigation actually involved the review and analysis of hundreds of thousands of pages of documents dating back 5 years and involved all the employees, both past and present, of the Livingston County Jail, as well as some other Sheriff's Office personnel. Many experienced and talented members of the New York State Police, including some of their most senior investigative members, poured through documents related to over 50 employees of the Sheriff's Department, including emails, time and attendance reports, jail daily logs, statements from witnesses and employees, and biometric records from our new jail, which opened in 2011. This was done for a 5-year period and involved thousands of hours of tedious work. To put it in perspective, I ask you to imagine reading 50 separate employees' bi-weekly timesheets for a 5-year time period, plus minute-by-minute daily jail logs for nearly 2,000 days, hundreds of overtime slips, the email records of nearly 50 employees, and biometric information from the new jail that began housing inmates in January 2011, all from the perspective of an outside agency, which the New York State Police was, with no prior information as to the inner workings of the Sheriff's Department. This was a task the members of the New York State Police faced, and this was simply to gather the information and meant nothing relative to being able to analyze it and then presenting it to my office for possible criminal prosecution. I respect and admire the hard work and thoroughness of the investigation by the New York State Police and know that they left no stone unturned and no document or email unreviewed. Speculation about the stalling of this investigation is an insult to the members of the New York State Police and to the staff of my office. And I would challenge any law enforcement agency to do a more thorough or quicker review of a case of this magnitude and sheer volume. I believe it is fair to say that each and every individual involved with this case would have preferred the case be concluded a year ago. However, everyone must understand what needed to be reviewed to get to where we are today. Further, there is absolutely nothing or no documentation which supports the notion that the Livingston County Jail had anything less than the appropriate number of correction officers actually working or appearing for a specific shift. And that includes the period of time from when the investigation was commenced and also during the 5-year period incorporated in the investigation. What the investigation did reveal, however, was a history and culture of permitting and in fact encouraging the employees of the jail to alter and effectively lie on their time card documents, a majority of the time with supervisor knowledge and approval. I understand the possible concern that only a select few jail employees have been charged with criminal offenses as a result of this investigation. Yet, not one member of the administration stands accused. I intend to fully address this in a few moments, and must remind you that the role of my office was solely from a criminal perspective and was focused on what criminal conduct could ultimately be proved in a court of law. This investigation essentially showed two separate practices that were ongoing in the jail over a period of many years. Practices that were immediately halted once retired Sheriff John York was made aware of this issue at the end of 2012. In addition to the efforts of retired Sheriff York, I stand here fully convinced that under the administration of Sheriff Dougherty, there are additional safeguards in place to ensure these practices do not and will not occur again. And I respect and commend our current sheriff and his administration for all their hard work and dedication in overseeing our county jail. In terms of what these safeguards are and the day-to-day oversight of the jail, I would respectfully defer to the sheriff and can assert to you that he has always been open, accessible, and available as we worked through and concluded our investigation into the jail employees that he began overseeing this past January. Sheriff Dougherty inherited this ordeal in January of this year, and much like I was saddled with this investigation only 7 months into my term as district attorney. The staffing of the Livingston County Jail consists of a chain of command, which begins with the sheriff and the undersheriff, and during the 5-year period which was reviewed as part of this investigation, a jail major and then other command staff. The employees of the jail were engaging in two separate and distinct practices, the first being shift swapping and the second being pay for work, or what I also call substituted labor. Shift swapping was rampant throughout the Livingston County Jail, with one officer agreeing to trade shifts with another officer. This was a permissible practice known by the administration of the sheriff's office and traditionally a customary practice that was accepted by everyone. The difficulty with shift swapping was trying to pay back the shift within the same 2-week pay period so that a time card would not have to be manipulated. A classic example was to trade an 8-hour Tuesday shift for an 8-hour Thursday shift that same week. However, there were times when the shift could not be worked back within the same pay period, which for our county is every 2 weeks. These swaps were usually done, again, with supervisor approval and have been ongoing for many years and were in fact a recommended practice by the prior administration. The investigation showed nearly the entire jail staff was involved in shift swapping, which at times involved providing misleading information on their time cards. Again, this was done with supervisor approval, with officers being told it was a customary practice and having their misleading time cards signed off on by supervisors. No individuals who solely engaged in shift swapping have been charged in this matter, as it is clear they were just following the directives of their superior officers, were doing what they were expressly authorized to do, and needed to shift swap in order to get someone to cover their shift when there may have been no other way to get that shift staffed. In many respects, the shift swapping at the jail was much like any other place of employment. However, was complicated by the jail being staffed by both part-time and full-time employees who were contractually limited on how much they could work without having to receive appropriate overtime pay. To further complicate the matter, there were times when it would be difficult, if not impossible, to work back a given shift within the same 2-week pay period. When this would happen, the employee who actually worked would not claim any time on their time card, while the employee whose shift he had covered would claim 8 hours of work. The work schedule would generally reflect the substituted coverage, meaning the employee who actually was doing the work would be listed on the schedule as working for the employee who wrongfully claimed the hours on his time card. In this respect, the supervisors knew who was working and in many instances were aware of the shift swap, yet allowed and authorized false information to then be placed on that individual officer's time card. The 9 individuals who have been charged in this matter all engaged in repeated shift swapping during their tenure at the jail, but it's the second practice, the pay for work or substituted labor, that ultimately formed the basis for these charges against only these 9 men. The pay for work can best be described as members of the correction division would also engage in a practice where they would pay another officer to cover their shift, traditionally with a rate of $100 for an 8-hour shift and $50 for 4 hours of coverage. This money would usually be paid in cash and would consist of the payer indicating on their time card that they worked, while the payee would not claim any time on their time card. Many times, the substituted shift coverage was done with supervisory approval and would be reflected on the schedule. However, the entire investigation revealed no information that shows that rendering payment was an approved or allowable practice. What I mean here is that the supervisors were aware that one employee would be swapping with another employee, yet these same supervisors never expressly allowed nor authorized the exchange of money to cover the shifts. In fact, there is email correspondence and other information as part of the investigation that the supervisors had made it clear that exchanging money for shift coverage was not allowed. And in the words of a former major of the jail, directly to jail staff several years ago, to pay another employee to cover your shift would constitute criminal conduct. The arrest on Friday stemmed from this pay-for-work practice, with proof in admissible form that shows that each of these 9 gentlemen went above and beyond what was authorized, basically lied on their time card about working that day, and then paid a coworker to cover their shift. All 9 of these individuals went farther than they were expressly authorized to do, and engaged in a practice that others in the jail did not. Based on a customary practice and the overlooking by the former jail administration, these former employees were authorized, and in fact permitted, to lie on their time cards, yet went beyond that and engaged in clear criminal conduct by paying others to work for them. There is further information that in some instances, these arrested employees falsely claimed overtime that they did not work, but rather had another employee cover that period of time. In reviewing the case against the 9 arrested individuals, there is clear evidence which would establish that each and every one of them deliberately lied on their timesheet, failed to actually work shifts they claimed on their time card, instead paying another employee cash to cover for them. In some instances, these employees would claim 12 hours of work on their time card, which would include 4 hours of overtime pay, yet never even step foot in the facility. These 9 gentlemen also gave written confessions and statements to members of the Sheriff's Department after being given their Miranda warnings before my office was even involved in this investigation. And these are ultimately the statements that were used as part of this case. The statements that were given to members of the Sheriff's Department were supported by the documents reviewed by the New York State Police and by my office. Without these written statements taken by the Sheriff's Department before my office or the New York State Police were even involved, this case would have been difficult, if not impossible, to prosecute. A huge obstacle in piecing together a criminal case in this matter, in addition to the sheer number of documents and people involved, was a difficulty in differentiating between what would be a shift swap, covering another shift for another, and a pay for hire, as the pertinent documents would always show who was present at the jail on a given day, but did nothing to show when payments were rendered. The voluntary statements of these 9 men are what solidified the criminal charges and were reviewed in conjunction with a dozen more voluntary statements that were taken by Sheriff's Office employees before the state police were even involved. A majority of the employees of the jail refused to speak with members of the New York State Police once they were brought in, and were either unwilling or unable to provide evidence that could formulate the basis for criminal charges against the administration. The arrest and prosecution of these 9 gentlemen was again based on their actions of going above and beyond what had been authorized, and was an abuse of customary practice of simply swapping shifts that was in place at the time. In terms of the administration of the Sheriff's Office during this period of time, there is absolutely no evidence that shows Sheriff John York or Under Sheriff James Cesniak were aware of these pay-for-work practices, but rather evidence that shows that once they were informed, a directive was issued that this practice cease immediately. Again, I must stress, the current members of the Livingston County Jail staff refused to cooperate with the state police investigation in potentially giving up any information which could implicate either the prior sheriff and his administration. Further, it is readily apparent that the major in charge of the jail did not authorize this practice of paying, but we also surmise that when he heard rumors of payment, he merely made statements that this would have to stop, was not a permissible practice, yet took no affirmative action beyond that. This is offensive to myself, the New York State Police, the current members of the Sheriff's Department, but standing alone is not criminal. This same major resigned and retired from the Sheriff's Department prior to the involvement of either the State Police and prior to this case being brought to my office. I'm going to defer any questions related to his prior employment with the county, the terms and conditions of his resignation and retirement, to county officials who, again, are not present here today. I must stress that I am personally offended by the lack of oversight and accountability on the part of the former jail administration, and believe that much of the blame in this matter should fall upon them. However, again, their omissions do not rise to criminal conduct, and at this time, based on the information we have after 17 months of investigation, cannot support criminal charges against anyone in the administration. When I became district attorney just over 2 years ago, I made a promise to the people of the county, and I always will stand by that promise. If my office charges it, or if we indict it, we will prove it. In this case, criminal charges against the administration of the jail staff cannot be proven in a court of law. I must again stress that while much of the blame in this case falls upon the malfeasance of these jail administrators, each and every defendant who was in court this morning went above and beyond in abusing the system, and in turn committed a criminal offense, and in the end paid the ultimate price in losing their job. With the resignations of 7 members of the Sheriff's Department last Friday, and the prior resignations of 2 others, presumably based on information they were going to be arrested as part of this investigation, I saw fit, and my office saw fit, to have these cases disposed of in short order in court this morning. All 9 of these gentlemen lost their careers as a result of cheating the system, and before last week, each one had a record devoid of any criminal arrests, and in the opinion of my office, did not warrant and merit a criminal record. By resigning their positions, any issues related to their potential credibility and integrity as future witnesses as members of the jail staff was eliminated. Further, there are no issues as to restitution for a majority of these gentlemen, as it was readily apparent that the work or shifts were always covered by another employee. The results of the criminal investigation do nothing, however, to preclude any further remedies against any of these men by members of the county government or any state or federal agency. It has been a long 17 months, yet it is time to move forward and to allow those who still remain employed at the jail to move on, at least in terms of avoiding criminal liability. This entire case has been extremely divisive, and in reality, there will never be closure. If nothing else, the investigation clearly showed a jail that was understaffed by the prior administration. It exposed serious flaws in the county contracts with the jail employees that allow part-timers to only work a set number of hours, and depicts the strain that all county governments are facing, which basically is trying to do more with less. In this case, trying to cut down on the number of jail employees, trying to cut back on overtime pay, and trying to limit the amount of vacation or sick time that these employees could use, ultimately led to a pattern and practice of authorized lying, which has tarnished the reputation of all those who have ever been employed at our county jail. We should take solace in the fact that the jail always had the right number of people working, that the county was always getting the services rendered, that the jail and the inmates were always secure, but that this required the manipulation of time cards. I wish to thank the New York State Police, especially Senior Investigator Dennis Kemp. I commend Sheriff Dougherty and his administration, including Chief Deputy Jason Yasso, for the changes they have made to ensure that something like this does not happen again. As always, if any additional information becomes available or pertinent information somehow surfaces, we will of course reopen and review the matter with full force and effect. As it currently stands, however, this will effectively conclude the criminal portion of this case based on this information that we have at this given point in time. Are there any questions?
Sean Carroll, 13 Wham. How are you able to say unequivocally that there's no crimes that the administrators or supervisors could face in this?
Again, this was solely the criminal investigation, and what we have is we have to show knowledge on the part of the supervisors that they knew and they authorized this to go on. There's not one section in the penal law, and trust me when I say we looked, that would apply to the members of the administration based on the information we have. There's no charge which fits the conduct they had. They authorized lying, but they did not endorse the pay for hire.
Their names, or at least one of their names, had to be on those timesheets. Wouldn't that be offering a false instrument for filing? Just the same charge that you just charged those 9 deputies?
The way the time cards are presented is the individual employee writes the hours down, say 8 for a given day, and there's an exact notation which basically says the entries are made herein are under the penalty of perjury and basically on the officer's representation. That was then being approved by the supervisor. I absolutely agree that these supervisors weren't diligently looking through the logbooks and the schedule to see who actually worked. But again, they were basically signing off on what that officer put down. And there's no way to say that that officer didn't then work those 8 hours at some other point in that time period. There's an absolute proof problem there to say, because you said you worked Tuesday, but maybe actually worked that following Thursday, that wouldn't fit into the total 80 hours for that pay period.
And you're telling me you couldn't find perhaps 9 witnesses that would help corroborate a case against any of these supervisors? Maybe more than 9?
As I indicated, the New York State Police were met with resistance, and I think a lot of that stemmed from the fact that these jail employees were interviewed by members of the Sheriff's Administration, by former Under Sheriff Sesniak, by his investigators. They were given their Miranda warnings. They basically gave full statements relative to this matter, thinking it was not a criminal investigation. And then next thing you know, the state police and my office is involved. So again, it's something that, while I'll say the investigation's never closed, I would love to see information come to light, but at this time, after 17 months, we have nothing that could criminally stick against any of the prior administration.
So you arrested these men based on statements that they didn't think were part of a criminal investigation. Is that what you just said?
These men were arrested based on voluntary statements they gave after being read their Miranda rights, waiving their Miranda rights, and then on thousands of pages of documents which supported the case. And I know you were present here in court this morning. They ultimately entered a plea today. There was clearly criminal conduct by these gentlemen.
Did you or state police ever interview Major Jim Rose, Under Sheriff Sesniak, former Sheriff York, or any of the other jail supervisors in the course of this investigation?
I'll defer that question to the state police.
We attempted interviews of everybody in the jail. We had no cooperation. No one would come in and be interviewed by us. We did interview Sheriff York and Under Sheriff Sesniak, who both denied any knowledge of this happening. Anyone else in the administration refused to cooperate with us.
So they gave sworn depositions or statements denying that?
We did not take depositions from them, but we did interview them. We took the information from them.
And took their word for it, that they didn't know about this?
Without any corroboration or cooperation from anyone else involved in this investigation, you cannot disprove anything they're telling us. The members that were arrested refused to cooperate with the investigation to let us know or give us a name. Did somebody authorize this? Did they not authorize it? Without that cooperation, we cannot go any further with anyone in the administration.
Mr. DA, you negotiated plea deals with these 9 men. Would you ever have brought, or like to have brought, a sworn deposition from the undersheriff or the sheriff to these 9 men to see if they can corroborate or basically disprove those statements?
The state police did a very thorough and diligent investigation here. As I indicated before, they left no stone unturned. I personally met with many of these arrested employees with their attorneys before. They were given ample opportunity to come up with any and all information relative to the prior administration. And frankly, I do not believe that information exists. There's absolutely nothing indicating the prior sheriff or undersheriff had any knowledge that this was going on. I understand the concern many people have, the prior reputation of Sheriff York, that he knew everything that was going on. But again, I believe when Sheriff York says he did not know this was going on, I quite frankly remember the first conversation we had about this, and he was shocked and appalled that this was going on.
So you took his word, but not the word of these 9 or 10 men or whoever else you interviewed, that these supervisors knew what was going on. But you believed his word, not theirs.
Not one of these men ever said that Sheriff York or Undersheriff Sesniak knew this was going on. There were rumors and speculation that Major Rose, who was the jail major at the time, knew this was going on. And we also believe that to be the case, that he knew this was going on, but there's absolutely no information that he ever authorized it. That's what distinguishes these guys. Lying was an authorized and approved practice. Whether we agree with it or not, that's how the jail was run. But paying was expressly prohibited. There's emails, there's conversations, there's speculation that if you pay, that would be criminal. You cannot do that.
If this happened over the last 20 years, how are you so sure that only these 9 men were responsible for lying and for paying for hire?
Well, what we did in this case is the state police went back a 5-year period. That was initially done given what we perceived to be, one, a statute of limitations, and also just to the sheer volume of the people we're looking at. We merely went back 5 years to begin with.
And you really don't believe there was any more than just 9 people involved?
The 9 people that were arrested, there's clear criminal conduct can be proven in court. I absolutely think there were other people paying. But again, we can't prove it, and I'm not about to base a criminal charge on mere speculation. The documents we have, the thorough investigation by the state police, supported criminal charges solely against 9 people. There was no one else we felt like we could actually charge and then subsequently get a conviction in this matter.
Sheriff, can you step up to the podium and give a comment? Go ahead, Berkeley. Just your reaction to what happened today.
Yeah, it's upsetting. This whole thing's been upsetting. Coming into office January 1st, it's not a way you want to start your term, but hey, it's a situation we're dealt. I'm relieved at least we can move past the criminal side of things and get on with business here. But certainly it's been a couple hard weeks. These folks are like my family. I've known some of these guys 20 plus years. It's a small community, so it's tough, no doubt about it. It's tough on me personally, it's tough on our office, and let's face it, this whole thing's tough on a community. We're Livingston County, it's a small community, and people care about people, and I hear arguments both ways on this, but Friday was a difficult day, and today's a tough day, and it's tough days ahead for everybody.
Sheriff, did you work with the district attorney to execute or extract the resignations of these 9 individuals?
No, the resignations came. The employees with their attorneys, many talks were had. No direct talk on the record with any employee, but in roundabout conversations, I was not shy in telling my command staff if someone was arrested that I would suspend them without pay. I just believe if someone does face a criminal action that they should be suspended till we figure out what's going on the criminal side. And if they were convicted, then I would seek termination on these folks because that would lead to issues down the road with their credibility. So
A conviction on a violation or a conviction on a misdemeanor?
if
or
someone was
felony?
convicted of a crime or really any time lying on a statement, that certainly would lead to problems with credibility. So under my administration, I certainly don't condone lying. I certainly don't approve of any signed documents that aren't true. So again, there was no deals made here, but I had it wasn't a secret that I would seek suspensions or seek termination if convicted.
But these men only received a violation at the end of the day with these plea deals. Violation, very much like a speeding ticket anyone could get. So your reaction to that, I mean, should they really have resigned, and would you have forced them to do that after today?
I mean, I can talk what ifs, but that didn't happen, Caroline. And again, they came in and resigned on their own. So I didn't take any action on these deputies, and I'm not saying that I would not have, because if I'm thinking ahead, if this did go down and they didn't resign, I absolutely would have taken action. And I believe as sheriff that is my responsibility, and that's what the people would want, is for me to take action, and so therefore I would do that. But in this case, I didn't have to take any action.
And you wouldn't rehire any of these men if they reapplied for an opening?
Again, I feel that these men, it's direct duties. If this was outside our work environment, then maybe that's something different. We all make mistakes. Heck, I've made mistakes. Everybody in this room has made mistakes. But when it's directly related to their job performance and inside our building here, then yeah, there's issues with that. And no, at this point, I mean, I haven't seen the internal investigation on this, and I have my own digging to do now on the personnel side of things. But based on what I've seen and what I've heard, and that they've taken a plea. Now, it doesn't matter if it's a misdemeanor or a violation, they pled to what originally was charged as a crime, and in that admitted guilt by saying that they lied on their time card. So I do think that there is some culpability with that.
So you wouldn't rehire them?
I would not.
District Attorney, did you ever think of bringing this case or anything before a grand jury?
There was some thought originally of bringing it to grand jury, either in the form of a grand jury report or to allow them to consider charges. But I think after figuring out exactly what proof we had, we realized it was actually a much smaller scope of what would have been provable conduct. I think the cost of doing business in front of grand jury was also going to be extremely difficult because it would require taking other employees of the jail and bringing them in as witnesses. As I indicated before, this was an extremely divisive case. It would have been hard because, not to mince words, you either would have been a suspect or a snitch in terms of jail personnel. And again, I think in terms of felony level conduct, I think it would have been a huge stretch to put it to grand jury to try to indict a felony, because you'd have to show an intent to defraud. So I think in terms of what we actually broke it down to, what we charged is what would have been easily provable in a court of law. I think to go too far beyond that would have been a stretch. And I think to basically put this to a grand jury, that really the proof fit what we charged, so we treated it like most of the arrests in this county.
Wouldn't a grand jury have gotten some more truth out of this situation if you just told me they wouldn't talk to state police, but your concern was they would talk to a grand jury? Why wouldn't you go at least the route that got you the truthful answers to consider charges?
I would invite any member of the current jail staff, former jail staff, or anyone in the public that has any information about anything that they wish to tell to a grand jury, to tell to my office, to tell to the state police to come forward. That's something we've done for 17 months. This has been an open door. That's
So they
how
were
we've
all
done
invited into the grand jury if they wanted to, a grand jury.
Any of these gentlemen who want to come in and tell us what they know, we'll gladly listen. And again, these 9 men today, well, these 8 today in court, they made the conscious decision. We brought them in through their attorneys, and we basically showed them what we had. We showed them the contents of the case against them. This was not a hidden ball trick. They saw their voluntary statement. We would show them their time card. We would show them the logbooks. We would show them the emails. We would show them corresponding voluntary statements given by another member of the jail. This wasn't like a surprise to these gentlemen. We showed them exactly what the case was, gave them the opportunity to make an informed decision and do what they saw fit, both in terms of employment and then ultimately entering a plea today.
And they were being honest throughout all of that, you believe?
I believe these guys
Forthcoming?
were extremely honest, absolutely. I think, unfortunately, to a fault, them giving the voluntary statements is what was their undoing.
But because perhaps somebody else didn't offer a sworn statement or just said, no, I didn't know about it, you're just going to assume that was also true?
I'm sure there's crimes all over this county that I don't have the information on. I can only
I'm
prosecute.
specifically talking about the sheriff, the undersheriff, or the major in this case.
I have no information that they were involved in any criminal conduct. I would welcome any information that anyone has.
Joe Tigliano, Genesee Sun. Is the time card system currently the same where the deputies still fill out their hours, or is there going to be more supervision? What lengths are we taking to improve the system that was faulted?
I would give that to the sheriff.
When I came in January 1, we specifically looked at that. In late September, the former administration used a biometrics scanning system, which is similar to a card. It hits on a door, gives their ID number and a timestamp. It also requires a fingerprint imprint. So they installed that outside the roll call, and then they put a camera over top, and that was late September 2013. That system is a good system, requires the deputy to be on that scanner 10 minutes prior to their shift and 10 minutes after. We did take that a step further post-January, and then we do a 5% audit. So the person reviewing the payroll, when it comes into the sergeant, he's required to do that audit, which requires him looking at the biometric system. Sometimes the scanner doesn't hit, which it does cause an issue, so then he has to go back to the camera that's mounted over top. Fortunately, we have not had any discrepancies in my administration, but there's written policy and procedure on it that says if there's any discrepancy, they're to notify me immediately, and a full-blown audit will be done of that payroll. So again, we haven't had that issue post-January, and again, I've made it very clear that I do not authorize any type of shift swapping. I do not authorize any type of pay for hire.
So there was roll call before every shift.
There is roll call at every shift.
Even
Correct.
even during the time when the substituted labor was occurring?
I'm only speculating. I've never worked in the jail side. So I believe, at least now, there's a briefing in between every shift at the jail. There's 3 shifts, there's days, afternoons, and midnights. But you have to remember, roll calls don't always, even now, have everybody in there. If there's a person still on a pod, we can't leave inmates unattended. So you do have carryover with people in and out of a roll call. But as I said, I can assure 100% to the taxpayers, this cannot happen through the use of biometric scanning, fingerprints, the camera system, and the audits. So,
Well, then for DA McCaffrey, then if there was roll call and members of the the deputies weren't showing up, or there was some sort of discrepancy, there wasn't anybody supervising that saw some discrepancies about deputies not being there when they were supposed to be?
Well, no, I think what the investigation showed is that on a given day, there would be a set schedule as to which deputies were supposed to be working there and which portion of the jail they would be working in. Most of the time, the schedule would accurately reflect who was going to be working that day. It may have a substitution. It may say, look, I'm going to work for you today, and it would have a little asterisk next to it. So the supervisors would typically know who was going to be there as the shift started, and they always had the appropriate number of people there. The problem became is that these gentlemen who were covering for others were then not only lying on their time card, but actually paying someone to work for them. So the supervisors typically knew who was there. And again, it was hard to distinguish between what's a shift swap and what's a pay for hire. And that's part of what made this such a prolonged investigation.
So the supervisors do. I mean, I got emails going back to 08 here. They approved and demanded that they approve all shift swaps. You're not denying the fact that all the jail supervisors knew or were expected to know who was swapping shifts.
Shift swapping was rampant in that jail for a period of years, absolutely.
And you couldn't make a case against them.
Again, shift
The
swapping was
supervisor.
authorized. It was absolutely allowed. I mean, that's something, it was a custom, a practice. The supervisors always authorized shift swapping. I believe there's quotes, and again, I speak to what the state police said before me. Sheriff York will stand behind every single shift swap that happened in that jail. He's gone on, and I believe he told the investigators that exact same thing. Every shift swap in that jail, I will take credit as authorizing. But never once did he authorize, nor did the undersheriff or the major authorize any form of rendering payment to have a shift covered. So that's why the shift swapping. If we chose to charge the shift swapping, every single employee in that jail nearly could have been charged.
And you just chose not to. You picked 9 guys to choose this particular crime that you pursued.
Yeah, we chose right off the bat to let go the shift swapping. The way they were charged was with offering false instrument for filing second. The other charge we looked at was falsifying business records. The penal law has an absolute affirmative defense to falsifying business record, which expressly says that if your supervisor or superior says you can do that, that is an affirmative defense. Going back to your question about grand jury, I guess we did basically jump that step to say these guys had an affirmative defense that they could have availed themselves of. So we basically availed that defense for them. There's a built-in defense in the penal law for falsifying business records. And again, the sheriff, head of the agency, approved that practice.
To lay anybody's fear, this was not a case where you didn't want to prosecute jail administrators or past sheriffs or under sheriffs.
I didn't want to prosecute county employees. I didn't want to prosecute jail employees. But the reality is, we can't discriminate in this county. If you commit criminal conduct, it's my obligation. I'm an elected official. I have a staff of 6. We will prosecute all crimes in this county.
Well, you're not prosecuting all crimes in this case. You're selecting which crimes you choose to prosecute.
Again, Mr. Carroll, I understand you have sources inside the jail. If any of them have any information of criminal conduct by anyone in the sheriff's office, I would love to sit down with them and would invite them to sit down with the state police as well, or frankly, to avail themselves of the whistleblower statute and tell the sheriff.
I'll help you with that.
Can you just, why wasn't anyone, was there any sort of negligence or just lack of encouragement to cooperate with the state police's investigation? Or because it became criminal that all of a sudden the deputies...
I can't speculate as to why the jail employees chose to no longer talk to the state police. I could assume I would know why, that basically they were interviewed by their own co-workers and own colleagues, and then next thing you know, the district attorneys and state police are involved. But I can't speculate as to why they chose to not give any and all information they had to members of the state police.
And they were given that option before offering their resignation as part of this plea deal. Go ahead, you sure you don't want to talk to the state
They were
police?
given that option many, many times since spring of last year.
And none of them
Repeated
talked.
opportunities.
So the only interviews Captain Allen, your office conducted was with Major Jim Rose. Did I hear you correctly on that?
We didn't interview Major Jim Rose. Well,
Major Jim Rose?
We interviewed, yes, I interviewed Mr. Rose at his residence.
Under sheriff, no. Sheriff, no.
Spoke to both of them too. Both of them.
But not sworn depositions. Same with Major Rose, no sworn depositions or anything like that?
He wanted to consult with an attorney before he did that. And he got an attorney.
And he chose not to give you any?
That's correct.
So you technically, all the statements you have in this case were handed over by the last administration as part of their review?
That is incorrect. The state police did gather some additional information from jail employees.
Sworn statements?
Sworn statements for people that were no longer employed there.
No longer.
Nobody that was
Gotcha.
employed there came forward
Okay.
and wanted to give any further information to me,
Including these 9?
including these 9. There
Thank
were
you.
multiple times that they were contacted personally, through their attorney, through the union, and they all decided not to talk.
Last for me, because I'm sure everybody's tired of me asking questions, but Greg, you've said a couple things about staffing. Just so I'm clear, you believe the jail was always adequately staffed, or this was the result of understaffing?
Well, I believe that until our current sheriff came here, the jail's always been understaffed just because of representations made by the prior administration. So I think in terms of, there's never enough employees, I guess, assigned to the jail on a permanent basis is the best way to put it. But in terms of each shift being covered, there was always the appropriate number to man the jail at that time. But we can always take more jail employees, especially now. I think that's the biggest problem. And again, I don't want to get into it, but I believe the Commission of Corrections has also reviewed that matter.
Did you ever consider just not making this a criminal matter and just handling it internally, or recommending that the county handle this with internal?
Again, the county and the sheriff's office, this is the criminal portion of this. I think these 9 people demonstrated clear criminal conduct, and that's why they were charged and ultimately lost their jobs. All right, thank you, everyone.